Hello, I'm Sarah Gonzalez with the National Grain and Feed Association. I'm here with Eric Conn, partner at Conn Maciel Carey in Washington, D.C. Eric, today we're at the Safety and Grain Quality Conference in Omaha, and you talked about employer rights during an OSHA inspection. And one of the things you talked about is that it has to be reasonable. Can you elaborate on what that means?
Sure, yeah. Section 8A of the OSHA Act gives OSHA its authority to conduct inspections, but it also gives a powerful tool to employers. It says that OSHA has the right to inspect, but that inspection must be at reasonable times, regular working hours, and in a reasonable manner. And what in a reasonable manner gives employers, I think, a powerful tool during the inspection to manage the scope of the inspection, the manner of the inspection. Where we see it come up most often is during document requests from the agency. The agency might ask for 5 years worth of training records, and it would take a truck to load up all those records to deliver them to the agency, where we might come back and say, we think that's a little bit more burdensome than it needs to be. How about the last year or the last 2 years worth of training records? And you try and find that reasonableness ground and get there. Similarly, for employee interviews, if OSHA is demanding that they talk to every employee right at this moment, that might not be reasonable based on what's going on in the workplace. And you can push back a little bit and say, you know, John is in the middle of loading a rail car. He can be available in 2 hours to come up here to the conference room and do the interview. And you find that reasonable ground, and you use that to sort of help manage the scope of the inspection.
Okay. And during the inspection itself, what's the most important part?
In my opinion, the most important part of the inspection is the opening conference. And the idea there is that that's your last chance to stop the inspection from happening if it's not supposed to happen. You know, for example, if OSHA's out on a programmed inspection that says if you've been inspected within the last 3 years, you're not eligible to be inspected under this program. So you can push back if that's the case. If they're there based on an employee complaint and you understand from circumstantially that the complaint is from a former employee and not a current employee, you might be able to push back and say, you know, OSHA doesn't actually conduct inspections of former employee complaints unless it's an imminent hazard that's discussed. They should do that through their phone and fax process. So you've got a chance to push back there and maybe make the inspection not happen. The other side of that is, an inspection is going to happen. The opening conference is your last best chance to narrow the scope. To say you're here on a complaint inspection about conditions in our maintenance shop, let's limit the scope of the inspection to the maintenance shop and just those complaint items. And you have that negotiation right then during the opening conference, and it's really your last chance to do that. So I think it's critically important to have a thorough and thoughtful opening conference before you let the inspector, you know, run amok in your facility.
Okay. And what are some maybe common misunderstandings or mistakes employers make?
You know, the most common mistake I see in the inspection process, and it's really, I think, a misunderstanding by OSHA that is shared often by the employer community, is that the right to a private interview, which is very, very important to OSHA, that OSHA believes the right to the private interview is OSHA's right, when in fact it is the employee's right, and it is only non-supervisory employees. A non-supervisory employee has a right to a private interview, but he also has a right to waive that. He can say, I want the company's attorney present, or I want someone from management present. And OSHA and employers and the employee butt heads on that issue all the time, because OSHA wants to get the manager out of the room. They want to get the company's counsel out of the room because they think the employee will be more frank and will throw the company under the bus if his supervisor is not there. But the reality is the employee can have whomever he wants present in this interview. And the way that usually plays out is he says, I want the company's attorney to be present for this interview. I'm more comfortable with him here. And OSHA says, no, I'm not going to proceed unless it's a private interview. And we say, well, that's fine. Then he's not going to participate in this voluntary interview. And OSHA may say, well, fine, I'm going to go get a subpoena. And the law is crystal clear that a subpoenaed interview by a regulatory agency, the witness, the person who is subject to that subpoena, has a right to have anyone present with them that they want, certainly any legal counsel they want present. And so, you know, what we end up saying to the inspector is, look, there's two choices. We can proceed today with me in the room, or we can proceed a week from now with me in the room. It's up to you.
All right. And are there a couple things that facility employers can do right now to prepare for a potential inspection?
Yeah, I mean, I think there's a lot of really smart things you can do in advance of an inspection to prepare for inspection. One is think about Who do you want to manage that inspection? Who is going to be your point person, your company representative? And this is one of the things that we often fight about with OSHA also, is that our chosen representative may not be present when OSHA walks in the door. You can ask OSHA to wait a reasonable amount of time. They think that means 1 hour. Really, it means whatever's reasonable. So think about, who do you want to be that point person? Think about how you want to manage that warrant versus consent issue. What are the circumstances that you might demand a warrant? And really give that some thought in advance so you're not forced to make a pressure decision at the time of an inspection. Think about where you want inspection activities to proceed. Where do you want to have an opening conference? Do you want to have it in your training room where you've got all your programs and procedures up on a shelf, where you've got your incident tallies and data up on a chalkboard and incident reports laying out on the desk? I don't think you do. I think you want to have it in a scrubbed, sanitized room, a conference room, an office, maybe not even in the elevator itself, but out at the scale house, something like that. The least sensitive areas that you have to walk through to get there, and the least sensitive information that would be visible to the inspector while he's there. Likewise for interviews, where do you want the interviews to take place? Think about all those things in advance so that during the inspection you're not required to make snap decisions.
Sure. Well, Eric, thank you for summarizing that for us.
Thank you very much. I enjoyed being here.
Thanks for joining us.